Good afternoon. Please be seated. We are here at the time set for oral argument on file number 2026-0027, Terrence Bjerke and Leverett Ole Larson versus the North Dakota Legislative Assembly and Michael Howell in his official capacity as the North Dakota Secretary of State. Sitting this afternoon are Justices Jared Tufte, John Jensen, Douglas Barr. Justice Mark Freese is disqualified, and District Judge Cherie Clark is sitting with us this afternoon. So thank you, Judge Clark, for joining us this afternoon. Arguing for the petitioner, Bjerke, is Zachary Wallen, and appearing with him is Jesse Walsted. And counsel for the Legislative Assembly is Brian Schmidt arguing, and Scott Porsberg is appearing. The Secretary of State's counsel chose not to argue this afternoon. So, Mr. Wallen, you may proceed when you're ready.
Good afternoon, Chief Justice, Justices, Counsel. It pleases the Court. My name is Zachary Wallen, and I represent the petitioners in this matter. With me today is my co-counsel, Jesse Walsted. The matter before the Court today is important, but also quite straightforward. In 2022, the citizens of North Dakota approved a ballot measure that enshrined political branch term limits into the state constitution as Article 15. Article 15 contains both the substantive term limits as well as a subject matter restriction in Section 4 that provides that those term limits may only be altered by a measure proposed by the people rather than by the Legislative Assembly. And yet, only a few years later, the Legislative Assembly has done exactly what they're prohibited from doing, proposing a constitutional amendment that would weaken those very term limits. This proposal, done without authority, violates two separate black-letter provisions of the state constitution that serve as a constitutional check on the Legislative Assembly. Therefore, petitioners are here today asking for a declaratory judgment that the legislature's actions violated the state constitution and to enjoin the Secretary of State from placing the measure slated to be ballot measure 1 in the November general election from appearing on the ballot. The first thing I'd like to cover very briefly is petitioners very sincerely request that this court does exercise its original jurisdiction and arrive in a merits ruling on this case. The reason why petitioners filed the case in this manner is to have a prompt resolution of this matter so that there's clarity for the voters and as well as for election officials statewide. Therefore, we ardently believe that this would be in everyone's interest for this matter to be promptly resolved. The second threshold issue I'd like to cover really quickly is just the very nature of the petition itself. This is a situation where petitioners are challenging the process by which SCR 4008 was proposed. And this differs from a past line of cases where there was more a challenge to the substance of a particular measure of how if approved by the voters, how it would affect a certain party's constitutional rights. The question here is, was the process that the Legislative Assembly employed here constitutionally permissible? And frankly, for the reasons we've shown in the briefs and here at argument, it is not.
Mr. Wallen, can that be the case when the question pits one constitutional provision against another? Don't we have to look at both of them and see which one supersedes the other? In order to, you're arguing this is process, but it seems like we have to get to constitutional questions to answer that, and that's not a simple procedural or process question.
I would argue that the measures can be reconciled and read together. I think specifically, as our first constitutional issue. Article 15, Section 4, expressly addresses the broader provision in Article 4, Section 16, that notwithstanding that broad authority to propose measures in this very narrow area of Article 15, Section 1, in terms of legislative branch term limits, that power is reserved solely to the people through a citizen-driven measure process. So that's how I would reconcile them, is through that very text. And frankly, we're here because despite that very express limitation of saying what the Legislative Assembly shall not do, they did it. And from the briefing, I can only really encounter two separate kind of lines of argument of why that was even okay. And the first is just largely a public policy argument, that they don't agree as a matter of public policy that such a limitation should exist on their authority. And that's fine to have that as a public policy provision, but Article 15, Section 4 is a part of the Constitution, and just like any other constitutional provision or statute must be followed, and it wasn't here. The second seemed to be just a broad argument that with the broad language of grant in Article 4, Section 16, that can just be followed instead of harmonizing in any way Article 15, Section 4. And I think, one, that sets aside kind of the clear language in terms of in Article 15, Section 4 about how the sections are supposed to interrelate. But also, even if somehow this was ambiguous and there were different provisions to apply and reconcile, their interpretation is simply just not how the rules of constitutional construction would work. First, the overarching principle is to, when there is language that may conflict, is to try to reconcile them together. I think Article 15, Section 4 expressly says how that ought to be done in this instance. And it also violates a couple of other different canons of Article 15, Section 4 is a much more specific restriction versus the broad grant of authority in Article 4, Section 16. And also, it is the much more recent voice of the people in speaking, that it's only a few years old and represents their more recent voice on the issue as well.
Counsel, do you think that the word notwithstanding elevates the Section 4, or excuse me, Article 4, Section 16? Does that, the notwithstanding word, set it above the general?
I think it does. I think it expressly shows what the people intended, that it recognized, that language recognized that this broad provision existed and was an attempt to harmonize them together. It expressly recognized it, and it expressly provided how they should interrelate.
Mr. Rowland, if part of the proposal is constitutional and another part of it is unconstitutional, are the two parts severable?
It's an interesting question. I think one of the things I would point to is just how much of SCR 4008 is related to Section 1. That it is almost the entirety of the proposed amendment. I think that makes severing them a little bit difficult in terms of the spirit of what was intended. I also don't think it's necessarily consistent with past court precedent of really not stepping in to rewrite things that are infirm. I'd point to something like Haugen v. Yeager, where the core issue was having that internal citation to a statute within the proposed amendment. Well, clearly this court, if it so had chosen, could have rewritten that in a way that was constitutional, but it's really not been the history from my reading of precedent of what this court has typically done. But then I think also, even if that was something the court was inclined to do, I think we'd have to apply the other constitutional infirmity here, which is Article 3, Section 8, the anti-tampering provision. And Article 3, Section 8 provides that a measure approved by the electors may not be repealed or amended by the Legislative Assembly for 7 years from its effective date, except by a 2/3 vote of the members of each house. Well, we're not anywhere approaching 10 years from when Article 15 was approved by voters, and neither house came close to a 2/3 vote. So in a scenario where this court would look to invalidate based on Article 15, Section 4, it would and was inclined to sever the provisions, you would at that point need to apply Article 3, Section 8 and see whether that applies, and we would posit that it does. The argument that the Legislative Assembly has made that it doesn't is that by proposing an amendment to the Constitution, it's supposedly merely proposing to alter or change these term limits as opposed to doing it itself. And I think there are a couple different problems with this. I think first, there's the fact that Article 3, Section 8 in that particular language says measure. It doesn't differentiate between types of measures, even though within Section 8 it does elsewhere. And obviously throughout the Constitution, where there's a need to apply to constitutional or statutory measures, the Constitution does so. So if that was the intention, one would have expected to find it in the text of Article 3, Section 8. But there's the other problem there too, which is to read it the way that the Legislative Assembly suggests would simply render all of Section 8 a nullity. That, even with statutes, which is what they're saying Article 3, Section 8 applies to, it's not as though the legislature single-handedly brings bills into law, that there's still a presentment element of, either needing the governor's signature or overriding a veto or the passage of time for something to become law. That, if we're merely restricting to, the legislature itself being able to repeal or amend on its own accord, then that would render all of Section 3, all of Article 3, Section 8 a nullity. So, and that flies in the face of the canon of statutory.
So doesn't the language of Article 3, Section 8 that says repealed or amended by the Legislative Assembly, it doesn't say are the people. The people can repeal and amend, correct?
Absolutely.
And so unless the legislature actually enacts something, how are they the entity repealing or amending?
What I would say is that this is their role in appealing or amending a constitutional provision.
They are not, it takes the people to actually do it, correct?
Yes, correct. But in the same way that for a bill to pass into law through regular statutory process, there's, again, that presentment element of it too. It's not as though they're acting single-handedly there.
One the people are voting on, the other elected legislators are voting, correct? There's a big distinction between the people voting and elected legislators.
I think that, but there was a voting element too in making the proposal, that was their part in the process of, voting and to a point of being able to propose a constitutional
The
amendment.
legislature's vote did not repeal or amend. Correct.
Correct. That's merely that part of the process, the same way with putting a statute into law, that's only part of the process that way too. And I think the consideration here is what the effect of a more narrow reading of Section 8 would be more globally. So, in conclusion, those are the two black letter reasons why SCR 4008 is a legal nullity, and consistent with past precedent of this court in these types of process challenges. This court in cases like Haugen and Meyer v. Askew, when there's been something deeply problematic about the process by which a measure was proposed, this court hasn't had the people of the state vote on a legal nullity that would have no effect. And therefore, consistent with that precedent, we believe that enjoining the Secretary of State from placing this legal nullity on the ballot is required here. Unless there are any questions, that's all I had. So I'd rest except for rebuttal.
Thank you for your argument,
Thank you.
Mr. Long. And Mr. Schmidt, when you're ready.
May it please the court, counsel. Petitioners request this court exercise its original jurisdiction to prevent the people of North Dakota from voting on a proposed amendment to the North Dakota Constitution. This court should follow its precedent, as well as the precedent from numerous other state courts across the United States, we've cited in our brief, and deny the petition. Now, this proceeding is unique because the petitioners request the court to rule on a proposal that currently has no legal effect whatsoever. The proposal that the petitioners seek to keep off the ballot is Senate Concurrent Resolution 4008. Now, SCR 4008 proposes to repeal Section 4 and amend Section 1 of Article 15, which is the term limits amendment to the Constitution. But SCR 4008 has absolutely no legal effect unless the people approve it at the polls. The issue before the court today is simply just not ripe for adjudication, and any decision except dismissal of the petition would be an advisory opinion, which this court will not give. Article 4, Section 16 of the North Dakota Constitution authorizes the Legislative Assembly to propose any amendment to the Constitution. Now, such proposal can originate in either chamber of the Legislative Assembly. If a majority of the chamber approves a proposal, it must be submitted to the electors. The majority of the electors must approve that proposal for it to have any legal effect whatsoever, for it to become part of the Constitution. The Legislative Assembly has absolutely no power to amend the Constitution by itself.
I want to ask a variation on the Section 16 argument. You've just suggested we should wait until the voters have their say, but if hypothetically the legislature had a voice vote rather than a roll call vote, which would seem to be in conflict with Section 16, would we be properly enjoining placement on the ballot, or should we wait until after the people voted in that circumstance?
You're asking if there would be a procedural issue under Section 16. Or if they didn't get enough votes and it was still submitted to the secretary. I think that would be another good way of putting it. And I think that would be a completely different case. And that's not before the court today because there's no dispute that we did get a majority approval of this proposal. That'd be a separate analysis, I think. I think the court would really struggle with that. The way I would phrase it is we don't pass on the constitutionality of proposed amendments until after the vote. So I think restraint in that situation would also remain appropriate.
Don't we have to look at some constitutional provisions in order to decide whether or not it takes a two-third vote or the majority vote? Won't we need to decide part of that?
Well,
Because that's the argument, is that there should have been a two-thirds vote.
Yeah, and we're talking about Section 3 or Section 8 of Article 3. When we get to that point, and quite frankly, the Section 8 of Article 3 analysis doesn't require a very deep dive. Really what we're looking at with Section 8 of Article 3 is it only prohibits the Legislative Assembly from repealing or amending a measure. And there was a back and forth during the petitioner's initial argument, and I think that back and forth really hit the nail right on the head. The Legislative Assembly does have the power to repeal or amend a statute, An initiative can result in a statute. What Section 3 of Article 8 is saying is if there's a statute that's put into place through the initiative process, the Legislative Assembly does need a 2/3 vote under those circumstances. Here, that's not the case. The Legislative Assembly is completely powerless to amend or repeal a constitutional provision. That's left solely to the people. So Section 8 of Article 3 has no applicability to this case. Getting back to I think the primary argument, and the argument that the court should accept, is that there is nothing at this time, there's nothing that's happened of any legal significance. This has to go to a vote before there's any law. SCR 4008 is nothing from a legal perspective.
Did the legislature have legitimate authority to place this on the ballot in this way at the time they did it, right now as the Constitution sits?
Yes.
And tell me why.
A very simple answer to that, and it falls within Section 4 of Article 15 and within Section 2 of SCR 4008. Now, Section 2 of SCR 4008 was included for a reason, and that's the portion of the resolution that repeals Section 4 of Article 15. The petitioners conceded in paragraph 20 of their reply brief that the Legislative Assembly has every right to propose an amendment to repeal Section 4 of Article 15. Well, Section 4 of Article 15 is the only place anywhere in the Constitution that places a restriction on the Legislative Assembly's ability to propose an amendment to it. So if the people vote to accept SCR 4008, they're voting to repeal Section 4 of Article 15. Consequently, there's absolutely nothing in the Constitution that would prohibit Section 1 of the Term Limits Amendment from being amended. On the other hand, if the people vote to reject SCR 4008, nothing happens to the Constitution. This court has absolutely no reason to ever speak a word about SCR 4008. And that's part of the reason why this isn't ripe for adjudication at this time, why it's not ripe for an opinion, why any opinion that would be rendered would be strictly an advisory opinion.
Doesn't that reading make Section 4 entirely superfluous? Any attempt to amend Section 1 just has to bundle an amendment or a repeal of Section 4, and then there's no entrenchment, no lock-in at all.
It's not superfluous, because let's play devil's advocate. Let's say that SCR 4008 was completely silent as to Section 4 of Article 15. We'd have a whole different case before you, right? But that's not what's happening here. Or if we were going to sever somehow the different sections of SCR 4008, say part of it was fine, part of it wasn't. Well, it can't be severed. This has to be put together. And the Legislative Assembly was very careful in the way that it crafted SCR 4008 to ensure that if it was passed, there would be no constitutional infirmity under those circumstances.
So to be clear, the legislature is not asking for us to provide a partial remedy or to sever anything. It's all or nothing?
The way that it's presented, it's all or nothing. It has to be all or nothing. And the reason it has to be all or nothing is because Section 4 of Article 15, if SCR 4008 is passed, Section 4 of Article 15 doesn't exist anymore. And there's absolutely nothing else in the Constitution that would prohibit an amendment to Section 1. So the people are voting on this. They have an opportunity to speak their voice on this.
So hypothetically, if this went forward and the voters approved it, wouldn't we be right back here with another challenge that you say isn't ripe now?
That remains to be seen. I'm not going to predict the future on that, of course, but it's possible that someone could bring a challenge at that time, but at least at that time, we would have an actual law for this court to evaluate and to render an opinion on. It wouldn't be strictly advisory. We don't know how this election is going to turn out. The people haven't spoken yet. This court has always, with a couple of exceptions that I will talk about, always allowed the people to speak on these things. And this court and other courts across the country as well have said, if this passes, we'll deal with it then. If this doesn't
But
pass.
the public did speak on this. The public spoke on it when it passed the original constitutional amendment, and they said, legislature, you don't even get to propose a change. They've already spoken on it. You want them to, you want a second shot, or a second bite at the apple, not a first one, a second.
They spoke on the issue of amending Section 1. There's nothing in Section 4 that prevents the Legislative Assembly from making a proposal to repeal Section 4. They didn't put that in the Constitution. That's not part of it. The petitioners admit that the Legislative Assembly is completely within its authority to ask them that question, whether they want to repeal Section 4 or not.
But the question is, do they have the authority to appeal Section 4? And you're bootstrapping 1 and 4 together.
Oh, they absolutely have the ability to repeal Section 4. I don't think there's any
Right.
dispute about that. They admit that.
Right.
And if Section
Then you're
4,
trying to bootstrap 1 onto 4.
they go naturally together under these circumstances. They have to. The way that SCR 4008 is drafted, they go together. Section 1 cannot be amended without a repeal of Section 4. The people have the ability to go to the poll and vote, do we want to accept this? Do we want to reject this? And again, getting back to my point, if the people vote to reject this, it never becomes an issue for this court. This court never has to speak on it. And getting to the question that I received earlier, if there is a challenge later, well, at least we have an actual law that we're reviewing at that time. And we're not just rendering an advisory opinion on the matter. There's a couple of other things I just want to touch on briefly. And it relates to two of the cases that the petitioners mentioned during their argument, the Askew v. Meyer case and the Haugen v. Jager case. And they claim that these cases provide some guidance for the court on how to proceed. And quite frankly, they're incorrect in that assertion. For example, in the Askew case, the court enjoined the secretary from placing a referendum on the ballot. Now, what's the difference between a legislative proposal and a referendum? Well, a referendum has an actual legal effect. Once it's filed, it suspends the law that's being referred. There's a tangible legal issue at that point for the court to decide. So any of the cases dealing with a referendum are not applicable here. In fact, this court has never exercised its jurisdiction to step in and enjoin a vote on a legislative proposal. In the Haugen case, and there's some other cases as well where this court has stepped in pre-election under its Article 3 powers. And the Haugen case involved a review of the secretary's decision on the sufficiency of a petition. This isn't an Article 3 issue. The secretary has no role in this. The secretary is not passing on the sufficiency of the Legislative Assembly's proposal. So any of the cases dealing with this court's original jurisdiction under Article 3 are also completely irrelevant. And quite frankly, under this court's precedent, there's no basis for this court to inject itself into the legislative proposal process at this time because this issue is not ripe for review.
The Constitution at the time of those cases didn't have language that said, shall not have authority to propose. That's new since those cases, isn't it?
Admittedly so. I mean, the term limits amendment's only a few years old.
Right, so now we've got language in the Constitution that takes away the legislature acting as the people's agent to propose. And it seems like that violation's complete as we sit here, isn't it?
The only language that we're referencing, which is Section 4 of Article 15, is what SCR 4008 seeks to repeal. There's no dispute that the Legislative Assembly has the authority to do that. So that begs the question, and this is something that the petitioners have proposed, is, well, the Legislative Assembly could propose repealing Section 4 and then come back later and try to amend Section 1. What would be the point of that? Make the people wait longer for a change to their constitution that they want? I'm not aware of any authority for that proposition.
I think there are a lot of states that require amendments to their constitution to be passed by two different sessions of the legislature. It seems like that is actually fairly common to make the people wait.
That very easily could be the case in other states. I'm not aware of any authority whatsoever in North Dakota under our Constitution that would require that. And quite frankly, the Constitution is the people's document. If they want to make a change to it, why would we make them wait? What if there was an amendment that was just completely unworkable? Everybody knew it was unworkable.
But the question isn't, you're switching the focus. The question isn't whether or not the people can change it. They can. Initiated measure. The question is whether or not the legislature can propose the change. If the people wanted to change it, they could have done an initiated measure. There's nothing that prohibits them. No waiting, no standing in line. They could do it.
Sure.
So you can't switch. You can't switch between talking about the people's right to do it and what the legislature has done. Those are two different things.
Well, ultimately, the legislature doesn't have the authority to make any changes to the Constitution, right? That lies solely with the people. We can all agree on that. The only issue from a, I guess, doctrinal standpoint here is the Section 4 issue in Article 15. And that's the only thing that's prohibiting Section 1 from being subject to amendment by a legislative proposal. Well, if Section 4 is voted out of existence, there's nothing prohibiting the amendment to Section 1.
There's nothing prohibiting the amendment, but at the time of the proposal, there was binding law prohibiting the proposal, wasn't there?
Yeah, Section 4, I'm not gonna stand here and tell you that Section 4 says something different than what Section 4 says. I think we can all read it and come to the same conclusion as to the plain language of Section 4.
Then why isn't it right? I mean, this action has happened. We're not waiting to see what happens. Either the legislature complied with Section 4 or it didn't. We don't need to wait to know.
I would disagree with the concept that we don't need to wait to know because the proposal itself has no legal effect.
That their actions have occurred.
The action certainly has occurred. They voted on it. They passed SCR 4008. But
It
simply,
was unconstitutional at the time.
well, this court has said that it will not pass on the constitutionality of a proposed amendment until that process is complete. The process is not complete yet.
But it's the process that's unconstitutional, according to the Constitution as it sits today.
So that gets into another interesting analysis, because the only reason why someone could conclude that the process is unconstitutional is by looking at what the actual resolution says, right? You have to evaluate the wisdom or the constitutionality of that resolution to reach that determination. And this court has said numerous times that it will not dig into that at the pre-election phase. It will allow it to go to an election and deal with it if the proposal passes. In sum, the petitioners are attempting to prohibit the people from voting on whether or not they wish to adopt SCR 4008. This attempt must be rejected under this court's precedent. Petition must be denied because it does not present an issue that is ripe for review. Any decision on the substance of SCR 4008 or the merits of this case would be purely an advisory opinion at this time. Therefore, we request the petition be denied. Thank you.
Thank you, Mr. Schmidt. Mr. Wallen, you have 10 minutes for rebuttal.
Just a few points I'd like to touch on relatively briefly from what the Legislative Assembly just covered there. First, I'll let it pass without too much comment about the richness of the Legislative Assembly purporting to stand up for the people when the people are the ones that spoke on this particular subject matter recently and set this particular process in place that has not been respected. But as to the question of ripeness, we fully agree with the point that Justice Barr was pushing, that this matter is ripe now. That any infirmity that would have occurred has already occurred. It's a question about the process that was employed, the vote, on a procedurally unconstitutional measure would have no effect beyond what has already occurred. This is a process challenge to the process that occurred, and for that reason, this matter is ripe now.
Is it a fair characterization to say that what the petition is seeking is not to prohibit a public vote, but to prohibit the legislature from forcing a vote?
I think that's right. I mean, I think that's what the point we tried to make pretty plainly in our reply, that there's certainly a path to change the Constitution, that we have a living Constitution. It changes. The measure process changes. The Legislative Assembly knows that best of all because, beyond the measure we're talking about today, there are two separate measures slated to go before the voters at the upcoming election on the single subject rule, and in the fall on changing the percentages of what's taken to approve something, that this process evolves and changes over time. And that's what happened here, that term limits were passed, this restriction of a subject matter restriction on this agency grant to propose constitutional measures has now a limitation, and the petition's trying to stand up for the process that the people approved and put into the Constitution as Article 15, Section 4. The Legislative Assembly over and over, harps on this concept, kind of pushing the idea that this court will not pass on a measure, at this stage before a vote. I think first, I think we've cited the cases where that is not the case. The State Board of Education case from about 10 years ago really walks through the lines of cases of process versus substance and where this court has stepped in. I'd also encourage this court to look at the cases that the Legislative Assembly cites for this proposition and look at really what these cases say. I think they fall into two buckets. One are cases that are very clearly about questions about the substance of a measure, of if approved by the voters, that the substance of the measure would have some effect on some other constitutional right. And again, that isn't what's going on here. That's a question of the process. I'd also look that specific language they use about, will not pass on a measure. I'd encourage the court to look at those cases. I mean, one of the quotes is quoting from a South Dakota case. There's a quote to a treatise about cases in South Dakota and Colorado. And that's the case about both quotes in Hall and State Board of Canvassers. And it also ignores the fact of any case law from the last 100 years where this court has made a distinction between these process-type challenges versus more substantive ones. And finally, I reject the idea that SCR 4008 was carefully crafted to address this particular issue. I just would encourage the court to read it. It in no way addresses the interplay of the sections. They're together. There's no reference to the interplay at all. Finally, I mean, again, this is crafted as an action for declaratory judgment, and declaratory judgments by their nature are done at a specific moment in time. And at the moment that the Legislative Assembly proposed SCR 4008, it did not have the authority to do this. It doesn't have the authority today that if by bootstrapping these things together and in a hypothetical world where these are passed, that somehow this limitation would go away at some point in the future, I mean, that would invalidate any sort of restriction. I mean, that would just render that whole general concept as a nullity. That's all I have, Your Honors, unless you have any questions for me. We encourage the court to grant the petition and avoid this ballot measure. Thank you.
Hearing no further questions, thank you, Mr. Wallen, for your argument, and Mr. Schmidt for yours as well. This matter will be taken under advisement, and court is adjourned until Thursday, April 9th at 9:30 a.m.